Good morning, everybody. Welcome to this first semester seminar of the research group for climate, energy, and environmental law of the University of Bergen. That is now our new official name and title. And this is a seminar that we have been organizing with Professor Lee Hencher and two sets of speakers. Three speakers are going to be talking today on green transition, public procurement, large energy and infrastructural projects. And we have today with us Professor Peter Trepte from the University of Nottingham, and he works and has been working for many years in issues related to public procurement. And then we have two representatives of Inventura, which is a consultancy firm working in Norway and in the Nordics regarding different aspects and elements of public procurement. And we have with us Kristina Risvær. She used to be a student in the University of Bergen several years ago, and now she's a practicing lawyer with a lot of experience in different activities regarding public procurement. And also with her is going to be Erik Kvammer, that he has a master's degree on sustainability and law from Uppsala, Joensuu, and Tromsø, and also a law degree from the University of Stavanger, if I'm not mistaken. And we are going to start now our session. Each speaker will have, or each set of speakers will have 20 minutes. And I will give now the floor and the word to Professor Lee Hencher, that is going to introduce Professor Peter Trepte. Lee, the floor is yours.
Thank you very much. And thank you, Ignacio, for kicking us off. I'm actually calling in from Panama, which is very early in the morning here. But I understand Peter is on the other side of the world, so he's in the office. Also late evening, so we're quite an international audience today. I have had the pleasure of working with Ignacio this last 2 years, and we've managed to arrange a number of webinars and seminars. There are so many issues, I think, of relevance to the energy transition that I'm very glad we could put this one together on green procurement, which is, of course, a very important aspect and an increasingly important aspect of achieving this energy transition. And I'm very happy to be able to introduce Peter Trepte, who's in fact an old colleague of mine. We worked together at a law firm several decades ago. And Peter has also a PhD from the University of Tilburg, where I'm also a professor. So I have known him for many years, and I've always been very impressed by his total passion for procurement issues. What might be for some a rather technical subject, I think Peter transforms it into a sort of ballet that he's so keen on it and can, I think, take us through the complexities of green procurement. And I know he has his own ideas about this. Doesn't, I think, always think it should have to be so complicated. That was your standpoint always in the past, Peter. So I'll be interested to hear if you're still of that view, or if there really are new legal challenges that we have to think about. Okay, I turn the screen over to you. Thank you.
Thank you very much, and thank you very much for inviting me to this workshop. I'm not sure about a ballet. I don't think I can perform that. You can now see me on screen, so you'll understand that if we're talking of any dance, it's probably going to be the dance of the Sugar Plum Fairy rather than any delightful ballet. Now, I've been asked more or less to give a background, I think, to how public procurement applies in the energy sector, or how green public procurement is. I have to start from the beginning. I'm sorry about this. So how green public procurement has emerged, and both Ignacio and Lee said the emergence of green public procurement, and I think that's probably exactly the term I would use. It's the emergence. I'm starting the presentation by a reference to a comedy, The Accidental Tourist. I don't know if anybody's seen the movie, but one of the messages that comes out of the movie is that in the absence of planning, a holiday is likely to be chaotic. Now, far be it from me to suggest that green public procurement in the EU is chaotic, but I'd certainly suggest it's not a model of orderliness. And I think the authorities responsible for procurement, I mean, the part of the Commission that's been dealing with procurement, has certainly been a little schizophrenic in the past, and that is beginning to change. But it's very difficult sometimes to work out quite what is going on. Here I've put procurement in inverted commas, and by that I mean the authorities responsible for procurement within the Commission. I don't need to tell you that there are different parts of the Commission and that they don't always think in the same way. But procurement, so the people responsible for procurement, I have to say, have appeared to be, to a large extent, rather reluctant environmentalists. They've been pulled kicking and screaming into the green procurement area. And it may be not that surprising, I suppose, because the EU procurement rules have been designed for internal market purposes. They were very specific objectives. So the European directives, for example, have never been about good procurement or even value for money. I mean, there's lip service now paid to value for money in some of the texts of relating to procurement, but that was never the objective. The objective was always to ensure completion of the internal market, to create a single market for procurement throughout the EU. So there's always been this difficulty for the Commission and others in addressing green procurement or any other strategic objective, because the rules are set up specifically to deal with internal market, and they're not really designed for complementarity. So there is always, or very often, not always, but very often a conflict between the provisions relating to internal market and those that apply to other objectives, whether that be environmental objectives, social objectives, competitive objectives also. There's quite a lot of writing on that. And so the procurement directives have never really dealt with environment in a very specific way. That has begun to change, but that was not the objective. And there's always this fight, if you like, this battle between the objectives. And since the internal market objectives are the ones that are explicitly drafted into the directives, then that's usually what wins the day. They usually triumph over others. And because we're looking at the single market and procurement as a means of achieving the single market, the question has always been about discrimination. Does, for example, an environmental concern or criteria that's put into some procurement process, is that really about saving the environment, or is that really about discriminating in favor of local companies? I think since we're virtually based in Northern Europe, it's fairly evident that in Northern Europe the companies have been very good at green production, for example. They're much more aware of the environment, and local companies there are probably well established and ready to provide more environmentally friendly products. That's not the same. I live in Spain. I don't think that's the same in Spain at all, or Greece, or countries like that, where the companies are not so concerned about green procurement. And so if you put in, if Nordic countries, for example, put in an environmental criteria in their procurement rules, there's always this concern, for example, that it's about favoring nationals or regional companies above, allowing everybody in the European to come in. That's always been the problem. And for years, the Commission has been fighting against, at least in the early years, so up to, say, mid-2000s, the Commission has always been fighting against having environmental concerns put into the directives. And it's only thanks to the judiciary, so the European Court of Justice, which has taken a much more positive approach to green procurement, allowing different award criteria to be put in place. It's really thanks to that we've seen a change. Now, I say that I'm talking about the authorities within the Commission responsible for procurement, because there are clearly other parts of the Commission who are considerably more positive about procurement and see it as a mechanism for policy, as a tool for policy. And I think it's important to know that the Commission doesn't sing as one, and that is the problem. So just using the idea of planning, the accidental tourist idea of planning for your vacation. I've asked here, it's obviously a rhetorical question, because there seems to be very little planning or foresight on the part of the progress towards green public procurement. It's something that's happened incrementally, and I would say accidentally. Thanks to, I suspect, the jurisprudence of the European Court of Justice in the early 2000s, a permissive approach appeared, a much more permissive approach appeared in the 2004 directives. There wasn't so much positive reference to environmental characteristics, but it was allowed, it was permitted more and more. And at the same time, outside the public procurement authorities, if you like, so outside the directives, a lot of effort was made in trying to create green public procurement criteria for a number of product and service categories. So we have a requirement, for example, to take into account when purchasing energy consumption and sometimes some forms of emission. But these were voluntary standards. It was an attempt to persuade purchasing authorities to take these into account in setting their specifications. They weren't mandatory. There were several categories, over 20 categories, including, for example, the purchase of vehicles where they had to be environmentally friendly. And then again, outside the public procurement sphere, where there was the Energy Efficiency Directive, which was trying to look at energy efficiency or required energy efficiency in the purchase of products, services, and buildings. So there were things going on in terms of green public procurement, but they weren't done through the public procurement directives, which regulate procurement in the EU, and they weren't mandatory, at least not at that stage. Now, around about the same time, I think in 2012, there were amendments to the treaty. So we had the Treaty on European Union and the Treaty on the Functioning of European Union. And these were amended in order to include environmental objectives in the treaties themselves. And to the extent that environmental objectives were supposed to be incorporated into all community or union projects and activities. And shortly after that, because this was the time when the directives were being, the procurement directives were being amended again, new provisions were put into the directives amended in 2014, which took account of the environment in a much stronger way. Still not incredibly positive, but there were far more references to the use of green public procurement, environmental characteristics in different ways. And you can see that in the provisions that there are for using things like technical specifications. So now technical specifications, or since 2014, technical specifications could include environmental criteria. You could use them in the award of contracts. Up to now, the award of contracts wasn't permitted to look at the environmental characteristics so much, but it was very clear that that was possible after the 2014 directives. But still, all of this was still contained within the traditional limits, looking at discrimination and the fear that this was always going to be the case. So even if you're looking at or allowing environmental criteria, so for example, into the award, you're allowed to award on the basis of environmental criteria, they still had to be non-discriminatory, they had to be proportional, so necessary, and only what was, nothing didn't go beyond what was necessary. And they also had to be linked to the subject matter of the contract. And that's quite an important condition, which we saw imposed by the court originally, and then it's carried through the amendments to the directive. And what that means is that the environmental characteristic can attach to the product being purchased, for example. So, if you can look to see at the environmental characteristics of the production. The Commission never allowed that before, but of course, thanks to the court, that did finally become permitted. So you could look at the environmental impact of production, but you couldn't look generally at the environmental policy of the tenderer. So the tenderer couldn't say, well, I'm really green, I do this, I do that. But if it didn't attach to the actual sale, to the product or the service being purchased, then it couldn't be taken into account. And so all of these limits that have carried through throughout the progression of the European directives, they remain, even if there was a much better targeted approach in the 2014 directives. Also, and this is very helpful, life cycle costing was included as a specific possibility. Of course, everybody used that before, but it was allowed as a specific criteria for evaluation in the directive, and that allows for the concept of, or rather, it allows measurement of environmental impact to be taken into account in the award. So that was particularly helpful. Now, in addition to the permissiveness of the 2014 directives, there were also some very specific policy objectives put into the directive, and these created obligations. So this was not just talking about the limits placed on contracting authorities to use environmental considerations, but actually imposed some requirements. One of those was an obligation to enforce environmental laws. So tenderers had to undertake that they would comply with any national, international, or regional or European Union environmental laws and regulations, for example. And the failure to do that could lead to exclusion. Now, this is discretionary, so it wasn't that member states or contracting authorities had to exclude companies, tenderers who failed to enforce environmental laws, but they were permitted to do that. And many contracting authorities did put in place the possibility of excluding companies of tenderers for failure to comply with environmental laws. And another important aspect, or another important possibility, and this one is related to something that I know Kristina and Erik will be talking about. An addition was the possibility to reject tenders that are abnormally low for non-compliance with this obligation to enforce environmental laws. So if, for example, the failure to comply with environmental laws allowed the price of the product for sale to be lowered, to become low, then it would be considered, or could be considered, abnormally low for that reason, because it was based on an unlawful input to the production of the purchase. And for that reason, the contracting authority would be in a position to reject tenders based on that non-compliance. It's not an absolute possibility or requirement. If the contracting authority sees that the price is low or considers it to be abnormally low as a result of non-compliance with environmental legislation, then it can ask the tenderer for an explanation. If there's a good explanation, then that's fine. But if they can't justify the price other than on the fact that they have not complied with the legislation, then it's within the contracting authority's right to exclude them. The next step in the process, and I'm talking about this as steps, they're not all within the procurement sphere, by the authorities responsible for procurement, they come from the Commission. But the next step, if you like, or the next important stage in green public procurement, and this isn't specifically a measure related to public procurement, but that is the Green Deal of 2020. And that may well have an impact. I say may well have an impact. It doesn't yet have a particular impact because certain things still need to be done. As part of the Green Deal, there is this suggestion that there should be more positive obligations, not just encouragement, because up to now all we have is guidance which encourages green procurement, nothing that makes it necessarily mandatory. So the idea here is that there will be proposals to amend the public procurement rules, not yet done, to turn the obligations, or to turn it from a voluntary to a mandatory regulation, so that the obligations must be carried out by the contracting authorities. As I say, those are proposed, they're not in place yet. And what we do have instead is guidance. So the Commission has written lots of guidance telling us how we might be able to use green procurement in different sectors. But generally, again, it's always related somehow to the limits. So it has to be balanced against cost effectiveness, about technical compatibility, even about the ability to maintain competition. Because, if you restrict the criteria for participation by using environmental criteria, it's quite possible that you would reduce the competition. And since the directives are partly partly there to ensure the widest possible competition throughout the European Union, and that might well become a bit of a problem. So nothing yet, but that's somewhere we're expecting to see some positive impact coming soon. Now, again, outside the public procurement directives and in a more broadly international context, the Commission has recently been busy adopting some new regulations. I say recently. The one here I mentioned, the IPP, the International Procurement Interest, that's been around, or as a proposal, for over 10 years. So it's nothing new about the proposal. But it was only in November, December last year that suddenly there was a flurry of excitement and a lot of busyness about adopting this instrument, which had been on the books for such a long time. And at the same time, it coincided with the adoption also of another regulation, which was on foreign subsidies, and the intent of that was to ensure a level playing field. Now, this may be because of a perceived political threat, if you like, from the US and from China, and the circumstances surrounding COVID certainly helped in trying to make the Commission perhaps a little bit more bullish about protecting its markets in terms of procurement. The foreign subsidies is an interesting one, and again, this is important for something that Kristina and Erik are going to be talking about. We know that there are measures in place in Europe to prevent or to minimize the effect of state aid through national governments, but there was nothing in place to stop or to prevent subsidies by foreign companies to their tenderers. And so this regulation has put in place something rather similar, or put in place a comparable mechanism, if you like, where there's a foreign subsidy, that has to be notified to the Commission, and it will carry out an investigation. It only applies to very large contracts, so if the contract in question is above 250 million euro, then it could apply, but for large energy projects, that's probably not such a high figure. And the amount of subsidy must be at least 4 million euros. So there is a sort of de minimis rule here. If there is no notification, and in the event of all other types of contracts, then the Commission can start its own investigation into whether a subsidy exists, a foreign subsidy exists, and whether it has effect on the procurement markets in Europe. This could be started on the basis of a complaint, for example, by one of the competitors. The Commission in the investigation will balance the negative and the positive effects, but it can take what it calls, very interesting word, redressive action. So it could be that no award, it will prohibit the award of a contract to a tenderer who's benefiting from a foreign subsidy, and it could impose fines as well if that's not complied with. Now, at the same time as this, I said there is the International Procurement Instrument, but this is really much more about reciprocal market access, and it doesn't apply to GPA covered, government procurement agreement covered procurement. This is really where those agreements don't apply. And it came about in a way because the European Union was concerned that other international parties weren't taking their obligations seriously, and they wanted to make sure that the GPA applied better. So this was a mechanism really to try to encourage people to come around the table, to negotiate, to expand access. And if they didn't, if the negotiations weren't favourable, then the Commission has given itself power to limit access to markets, either to whole sectors or certain industries or certain values of contract. Only again above 15 million euro contracts for works and 5 million for goods and services. So reasonably high contracts, but still not so high. And if that doesn't work, if bringing them around the table doesn't work, if limiting access doesn't work, then the Commission is entitled to impose what they call a score adjustment. Of course, so they will change the price of the contract for purposes of evaluation. They're not going to change the price that's paid, obviously. And this could be, if we're looking at most economically advantageous tender, this could be up to a 50%. I'll call it a preference. They call it a score adjustment. If price is the only criterion, then this could be up to 100%. So it's a fairly significant price preference, especially when you consider the one that exists already in the Utilities Directive, which is only 3%. So these two measures, I think, are really important and show that the Commission is becoming a little bit more active, at least in terms of international procurement. But both of these, the foreign subsidy regulation and the international procurement interest, they're really about ensuring reciprocity and about trying to persuade foreign countries to provide better market access. They provide a means of reacting, a means of redress, where the Commission sees that there are some unfair practices. And although I think this is not particularly aggressive, I do think the new proposal for a Net Zero Industry Act, and I know Kristina and Erik are going to be talking about this next, it is still a step towards, I think, a more protectionist approach. I'm not saying that it really is offensive. It's whether they are on the offensive, whether it's now becoming a much more aggressive mood. But this is not directly in response, I don't think, to a particular market access issue. It is a response to the US's Inflation Reduction Act, and the EU is concerned that that might give the US tenderers an advantage. I will just very briefly say that they allow within this a weighting criteria for procurement purchase through tendering of 15 to 30% for sustainability and resilience. That's not particularly well defined, but it did work very well in the situation of COVID. Resilience was something that was permitted even under the WTO rules on government procurement. I'm not sure that it's going to be the same for energy self-sufficiency. That's something we have to see, assuming that this gets through. But really, the rules are a little unclear at the moment, and it's still just a proposal. But it does seem likely that this would apply where clean energy is single-sourced from countries from outside the EU, and that accounts for more than 65% of the supply. I won't talk about it anymore because I know Kristina and Erik will be discussing this now. So I will hand over the floor. I think I've run out of time. I will hand over the floor to both Erik and Kristina.
Thank you so much, Peter. I think you did a fantastic ballet as it was advertised. This was brilliantly presented. I must say, I thought your books were very clear, but after listening to you speak, you're even better presenting. So thank you very much. It's a great opportunity and chance for us to have you with us here. And now I pass on the word to Erik and Kristina. Erik and Kristina, there we go. We see you guys well. You are both working in Inventura, as I mentioned before. They are really procurement experts on the field, so they are working on practical issues. And Kristina used to be a student in the University of Bergen, and Erik has studied also law in Norway. And as you will see, they are going to bring us a perspective of how the acceleration of energy transition is done with the help of public procurement and green procurement. And they're going to bring their perspectives of people that work on this on a daily basis. And I would like to say thank you so much, both Erik and Kristina, for being with us here and doing this. Very excited to what you have to say. And we look forward to your presentation. Like with Peter, we will have 20 minutes. So that means that we have about 10 minutes for a Q&A session in the end. Maybe we will go 5 minutes over time if there's more questions around, because I see that there's a lot of people that are interested in what you have to say and what Peter has to say. So I'll leave it here. And Erik and Kristina, the floor is yours.
Yes, hello everyone, and thank you so much for the introduction, Ignacio. We are very grateful to be invited to contribute to this webinar and to speak our mind on some subjects that are quite close to home for us here at Inventura, namely strategic and green public procurements and energy transition. In our presentation today, we will attempt to, In our presentation today, we will attempt to display some connections between how green public procurements can contribute to the acceleration of the energy transition by increasing demand for low carbon and net zero technologies. On this slide, you can view our agenda in short. First, we are planning to give you an update covering recent regulatory developments relevant for public procurements and energy transition in particular. Then we're going to share our experiences as practitioners and try to elaborate on how to best implement sustainability criteria in practice in relation to the procurement process. And also, since Inventura is somewhat engaged with clients in the energy industry, and since this webinar covers the topic of energy transition, we will also share some insights in terms of how that industry is dealing with increased expectations in relation to environmental sustainability. So, let's begin. Starting off, it makes sense to remind everyone why public procurements are considered such an important measure to attain different societal goals these days, including energy transitions and net zero ambitions. Within the EU, expenses stemming from public procurements is estimated to amount to about the equivalent of 14% of EU's gross domestic product. And similar, here in Norway, it is calculated that we spend the equivalent of 16% of our gross domestic product on public procurements. In other words, the public spends significant sums of money, representing a substantial market power through its procurements. And since the public is paying the bill, this power should arguably be used as a measure to promote sustainable outcomes that benefits our society as a whole. Furthermore, we can also infer that public procurements has a substantial climate footprint. Here in Norway, for instance, it is estimated that the climate footprint stemming from public procurements amount to approximately 11 million tons of CO2 equivalents annually, or 16% of our total emissions. And similarly, in the EU, about 11% of their total emissions can be connected and attributed to their public procurements. So this illustrates quite the reduction potential that lies within the realm of public procurement. And this is probably also one of the reasons we see that both the Norwegian government in their climate plans and EU in their Green Deal policies points to public procurement as an important measure to reduce their climate footprint and ensure environmental protection and spur the circular economy. And on the topic of Green Deal, and more specifically the Green Deal Industrial Plan, it is in this respect timely to refer to the relatively new regulatory proposals for a Net Zero Industry Act and the accompanying Critical Raw Materials Act that were presented by the EU Commission in March. The reason that we chose to highlight these proposals is that they are interesting in the context that they both refer to public procurement as an important mean to achieve their goals, which both happens to relate to energy transition. The purpose of the Net Zero Industry Act is to strengthen European manufacturing capacity of different net zero technologies within the Union and to overcome barriers to ramping up the manufacturing capacity for said technologies. Whereas the purpose of the Critical Raw Materials Act is to diversify and enhance the resilience of EU critical raw materials supply chains, which also are crucial for the manufacturing of the net zero technologies covered by the Net Zero Industry Act. In terms of public procurement and its role under the Net Zero Industry Act, the proposal entails that contracts for net zero technologies shall be awarded based on the tender's contribution to sustainability and resilience based on predetermined criteria, and the contribution shall be given a weight between 15% and 30%. And of course, there are some exceptions. The Critical Raw Materials Act does not impose any obligation that at this point constrains the contracting authority's discretion in terms of what awarding criteria they must use, nor how much weight should be attributed to each criterion. But the proposal does, however, impose obligation on member states to implement national programs containing measures designed to increase the use of secondary critical raw materials in manufacturing, including, where appropriate, by taking recycled content into account in award criteria related to public procurements. So this could perhaps be a foreshadowing, of course, of future constraints in terms of predetermined award criteria that are to be used in the context of procurements of goods containing critical raw materials. But at this point, the provision first and foremost calls for an increased focus on the collection, treatment, and reuse of waste containing critical raw materials. Another interesting feature in relation to the proposed Critical Raw Materials Act is the delegated power that is afforded to the Commission to establish rules for calculation and verification of critical raw materials and their environmental footprint, which perhaps may serve as a basis for future certification schemes that may be used to develop environmental sustainability criteria in procurement procedures. And such schemes may prove very valuable in practice for our work in terms of credible verification of environmental performance. So both the Net Zero Industry Act and the Critical Raw Materials Act illustrate at least two trends in our view. For one, they illustrate how certain prioritized procurement categories are being regulated more in detail, and that contracting authorities are rendered less discretion in terms of how they want to implement sustainability criteria in certain procurement procedures. So a prudent question to ask in that regard is, what is the cause behind this trend, in which regulators are making environmental awarding criteria mandatory, including how much weight should be attributed to it? And why aren't contracting authorities trusted to make good decisions in terms of how to achieve sustainability goals they are meant to achieve through their procurements? It would appear that the answer lies somewhere in the fact that application of green public procurement criteria is very inconsistent across the board, wasting a lot of the potential that is inherent to public procurement as a policy tool. For up until this point, the legal regime governing public procurement procedures in Norway, and for that matter, the EU, has permitted a rather extensive application of environmental sustainability criteria on a voluntary basis, of course, during the various phases of the public procurement. So that's not really the issue. But despite being awarded considerable freedom to pick and choose when it comes to methods to achieve green public procurements, there is quite few indications demonstrating that contracting authorities actually seizes their freedom to do so. For instance, taking an example from the EU, where they over time have compared the proportion of green public procurements relative to all public procurements from 2006 to 2017, based on data from the Tender Electronics database. The statistics ranges from less than 0.5% in Malta to more than 15% in Denmark and France. And in addition, most EU countries only apply green public procurement criteria to procure less than 5% of their contracts. In other words, the use of green public procurement criteria appears to be applied quite inconsistently, and to an extent that is insufficient to achieve the goals of the public procurements are intended to attain. Hence, there lies an untapped potential there, and now we are observing that regulators are trying more and more to achieve this through less voluntary methods to make use of this potential and assure more consistent application of the Green Public Procurement criteria. The Net Zero Industry Act and the Critical Raw Materials Act represents thus examples at EU level of such instruments. However, now Kristina is going to present some similar and perhaps even more radical developments taking place in Norway with the revised Norwegian procurement regulation.
Yes, I am. I hope to give you quite a practical point of view on this. As part of developing and expanding the Norwegian model for serious procurements, the national government of Norway has tightened the requirements for safeguarding climate and environmental considerations in public procurements. This decision comes despite quite explicit criticism towards the proposals from a number of consultative bodies, and it will take effect from January 1st next year. So this is absolutely something Norwegian contracting authorities will have to take into consideration and implement into their daily procurements. The regulation is a bit broader than what we've seen in the EU acts, and the amendments means that contracting authorities are now obliged to weight climate and environmental considerations by a minimum of 30% in close to all public procurements, unless these consideration is best attended in the technical specification. The regulation also states that any or all deviations from this rule has to be justified in the procurement documents. The criticism towards the proposal was in large part based on a somewhat unfortunate balance between coercion and vague concepts. And it raises several key questions regarding how the provision should be interpreted. Some of these questions are, for instance, at what level of environmental requirements are expected in the technical specification to cover the need for climate and environmental considerations, and therefore justifying an exemption from the 30% rule. Furthermore, what does the term environmental consideration and climate and environmental requirements really entail Where is the threshold? And is it possible to use a combination of the weighing, a lower weighing, and technical requirements? There is also a need to clarify where the threshold for what constitutes a not insignificant environmental impact lies, and what will justify such exemptions from the rules. So we see this in our daily practice, and we have a few things that we find useful for all contracting authorities on how to implement sustainability in practice. And the challenges and uncertainty on the new amendment may pose a challenge to the use of the regulation. There are, however, measures enabling the contracting authorities to make the most of this amendment, creating both environmental and economic value. First of all, we recommend that all contracting authorities now look at their competence on climate and environment. And by that, I don't mean the legal competence, the competence of running a procurement, but actually specific environmental competence. I think going forward, we will see a lot more technical requirements of environmental safeguarding in the award criteria. Examples of such can be the use of greenhouse gas budgets or EPDs in construction. And this makes more specialized competence needed in order to actually understand and to be able to evaluate the documentation. Another effort contracting authorities now should make is to make sure that their framework, their routines and tools are up to date and adjusted to take environmental considerations in as an obligatory part of the process. In particular, I would like to see fixed routines and good tools for assessing the environmental impact of each procurement, as this can be used both to ensure that you have the necessary justification for exemptions from 30% rule, as well as making it easier to actually identify suitable and relevant requirements and award criteria when running the procurement. The third measure I would like to see contracting authorities now take more into consideration is to increase the focus on what value each potential environmental requirements or award criteria can give. In this, I can see a few questions that you always need to ask when looking at what requirements to put forth. But some of them might be, is the requirement sufficiently challenging? Will it actually give the market the incentive needed to create the development we want? Are the requirements of the criteria relevant? Hence, do they actually relate to the contract delivery? And can the requirement or criteria yield financial gain? I think in order to give the most incentive, we actually need to find criteria that both supplier and contracting authority will actually gain from. By taking these measures, contracting authorities can greatly contribute to developing the market, create added values and innovation. It is worth noting that the new rule focuses on the use of environmental considerations in the contract award criteria and technical specifications alone, not the qualifying criteria or contract requirements. That does, however, not mean that we should stop using environmental requirements in those phases of the procurement. For example, qualification requirements are a great way to screen out unsuitable suppliers without limiting competition to an extensive extent. Qualification requirements should be binary, and they should also be relatively familiar to the market and easy to document. When it comes to technical specifications, I think it's important to have a good knowledge of the market's maturity in order to know what sustainability-related requirements can be imposed on the product or the delivery. Suitable requirements for which the market is generally quite mature. In Norway, technical specifications are also quite often given by adjacent regulations from the government. Examples on this are, we have an act on emission regulations for vehicles for road transportations in public procurement. And we also had quite an extensive regulation on housing as an instrument for this energy transition. It is, however, important to ensure that one does not set up a single supplier situation. So any requirements in the technical specification should not be too strict. When it comes to the contract performance requirements, these ensure compliance during the term of the contract. And they may be suitable in situations where it's difficult to document fulfillment in advance of the contract. I do, however, think it's important for contracting authorities to consider the need and the capacity for follow-up, as this is one of the main pitfalls we see regarding contract requirements. However, the new Norwegian amendment mainly focuses on contract award criteria. These criteria should be directly relevant to the actual delivery, and also you have to be able to rank the criteria on the basis of the degree of fulfillment. These criteria are usually well suited to be used as incentives and tools to stimulate a more sustainable development in the market. This is also where any contracting authorities might aim slightly higher than the market's maturity in order to create such an incentive. There are, however, a few pitfalls we see a bit too often when it comes to the use of environmental considerations as contract award criteria. The first one I'm going to talk a bit about is giving the criteria a bit more weight than they're worth in order to fulfill your obligation to use an environmentally focused criteria. You use a criteria that might not be as relevant for the procurement that you wish. And this might often come at the expense of other more important criteria. Another pitfall is using too extensive requirements, resulting in the renunciation of suppliers that might in fact be a good fit for the contract. Thirdly, as previously stated, lack of competence to evaluate is a huge pitfall, and also entails the risk of misevaluation and sanctions following that. And the last one is actually using binary criteria that can only be answered yes or no, and are not good for separating the tenders. If, however, we can avoid these pitfalls, I think the new Norwegian amendment might have a great potential to drive forward innovation and sustainable development. And it might also contribute to a practice where requirements for climate and the environment are emphasized first and foremost, because it provides a noticeable added value in the procurement and also for the suppliers. These are the views from contracting authorities' point of view. Erik is now going to say a few words about how the industry is handling these requirements.
And
Yes.
Erik, just before you go on, just to give you a reminder that if you can wrap it up in about 3 minutes, that will be great. And then we will be a little bit over time, but not too much over time, to give chances to people in the audience to give us comments. I hope that's okay.
We'll try our best. And just a quick FYI, Kristina has to make a plane at 3, so we have every incentive to wrap it up. Yes. But before we conclude our presentation, we figured we would give a brief snapshot of the energy industry and how they are affected by these changing framework conditions. Our first observation is that most Norwegian energy companies, including both fossil and renewable energy companies, have net zero targets by 2050. The strategy to achieve this heavily relies on energy efficiency projects, electrification, and deployment of renewable projects. And of course, especially the electrification projects here in Norway have caused some controversy, yet they are considered by many to be a necessary evil to attain the Norwegian 2030 goals. Other high impact initiatives that we are observing are energy efficiency projects and phase-in of low emission vessels in operations. And there is considered to be many possibilities to increase energy efficiency on the offshore oil and gas installations through refurbishment of gas turbines and use of modified supply vessels fueled by ammonia or hybrid technology, including use of batteries. However, on another procurement categories, the industry is perhaps less mature when it comes to green procurement and could perhaps draw some inspiration from the public sector. Like, for instance, if you look at most of the Norwegian electricity utilities, most of these have public procurement approach and follow the public sector trend on green procurement. And finally, we're also seeing another driver of green procurement in the energy industry that affects, among others, developers of hydrogen and offshore wind. In both cases, green procurement is key in project contract strategies, and this is prompted largely by sustainability requirements for public concessions that they depend on to develop their technologies, as well as for project financing. One example is, for instance, the Norwegian offshore wind concession rounds for Sørlige Nordsjø and Utsira. So there are many drivers that creates greater consideration for public procurement also within the industry itself. And that more or less concludes our presentation. We have summarized some of our main points here in the end, but out of respect for time, I think we perhaps should conclude here. Thank you.
Thank you so much, Kristina and Erik. This was a very good overview of what's going on in Norway and the introduction of the 30% rule, also in light of the developments in EU law. So what I'll do is I'll stop the recording